Hi, Andy Nelson here. Some years ago, I had a client who created a flyer for a local festival using some graphic art that he got from a royalty-free website. And regrettably, it turned into a disaster where not only were there claims that he violated someone's copyright in a photograph, but he also violated someone's right to publicity because the artwork, which was based on a photograph, was of a human, and there were individual rights involved too. All of you, I'm going to guess, have probably heard some kind of horror story where someone got a cease and desist letter, maybe even a lawsuit for allegedly misusing somebody else's content. So what I want to talk about briefly today is just a few circumstances under which you may not need to ask for permission to use content that was not created by you. Now, the most obvious one, which a lot of you have heard of before, is work that is in the public domain. Now, before I say what public domain is, let's talk about work. When I say work, I'm talking about content ranging from graphic art to fine art to music, as in the sound you hear, the recorded sound, musical notation, lyrics, literary written works, photographs, architectural drawings. I think I've just about covered it all. I don't think I'm missing anything major, but all that sort of content we see used daily and used by other people using other people's content. You want to avoid those dangers. Here's some situations where you don't need to use it. Public domain. So things that are in the public domain are free to use by everybody. Now, things can be in the public domain for a number of reasons. One, they never had copyright protection or no longer have it. For example, you don't need to ask anyone's permission to use the Mona Lisa, okay? It's way too old to have any copyright protection. Other things like that are extremely old may also be in the public domain. Other things may otherwise enjoy copyright protection, but sometimes the authors, the creators, commit them to the public domain. So those sorts of things would be free to use. Works that are created, oddly enough, by the U.S. government are also free to use. The U.S. government cannot own copyrights. And then, so I think that covers everything in the public domain. So two, a lot of materials are just too short or too small to enjoy copyright protection. So short phrases, names, slogans, that sort of thing, those probably are okay to use as well. However, what you need to watch out for is trademark protection, because names, slogans, those sorts of things may not enjoy copyright protection, but if you use them in a certain way, they may infringe on someone's trademark rights. So that's something to watch out for. And then three, there's this concept called fair use, whereas even if something does enjoy copyright protection, if your use is for a particular purpose, there's a lot that goes into this analysis, so it's probably not something you should analyze in a vacuum, but analyze it with an attorney. This fair use concept might allow you to use certain works without getting permission from anyone else. The fourth thing is, even though I said, hey, I'm going to talk about ways you might use materials or use content without seeking permission, this one is kind of a hybrid. A lot of materials out there, and you've seen this before, I imagine, are okay to use. There's already licenses kind of, or permissions already attached to the works, right? These royalty websites, that sort of thing. So yeah, you kind of have to ask permission, but you kind of don't, because the conditions for use are already laid out. And so long as you follow those conditions to the letter, mind you, a lot of people don't read them or don't quite stay within the confines of those permissions. Those are situations where you can also use others' content without having to seek permission. It's already there and given, so long as you read about it and do it the right way. Anyway, those are the four ways: public domain, things that are just way too short or too small to enjoy copyright protection, things that are covered by what we call fair use. Again, you need to explore that further with a third party, with an attorney. Or four, permissions or licenses that are already canned, if you will, and already existing, provide a pathway to use others' content as well without asking for permission and negotiating the terms of permission. Anyway, if you have any questions about this video, please feel free to shoot me an email. I look forward to talking to you soon. Bye-bye.